me paying her attorney fees, me giving up all my rights as a dad, essentially to her, not being able to take my son out or make any type of mental health decisions for him, or just giving her everything where I'm susceptible to whatever she wants. That's what I don't want.
And what was your salary then?
135 a year.
At 135 a year.
But I only worked with them for about 3 months.
You said there was a discovery dispute.
Yes, Your Honor. So in this case, Your Honor, we have a temporary orders in place, no child support set yet. And we reset last time, so Mr. Lopez can give us some financial documents. And today, we were asking for those documents, and he said that he doesn't have them all, especially the W-2s for the last 2 years. And at one point he said that he'll produce them when we're in front of the judge. I said we really need these documents, before, so we can look at these, calculate the child support before the hearing. That's what we approached, Your Honor.
Okay, Mr. Lopez.
Yeah, so this last mediation meeting that we had, they told me that they were going to send me a link requesting these forms, what I needed. So that's what I was waiting for. The attorney, Mr. Gary, did ask me for that discovery link, and I told him all I've gotten so far is these papers that I printed out that serve me. So he did ask me if I had sent them to him, to his office already. Like I said, I don't know how, because I was waiting for a link to upload them so I could see everything that I needed to upload everything now. I know he did state that I would produce them once I'm in front of a judge. Well, like I told Mr. Gary, I still need time to get them. I wasn't expecting to see you right now. I can't produce them right now either because I don't have them. I wasn't trying to say I'm not going to produce it or give it to him. I'm just going to give it to the judge. What I'm saying is I don't have them. But since I thought Mr. Gary was an attorney, there's a lot of things that I just saw in this. I don't know if it's a temporary orders or whatever I was sent that I don't want to agree to. So that's why I was like, oh, I just want to see with the judge, because I don't want to produce everything, give everything, and then say, okay, well, now this is it. Because there's a lot of things here after I read it that I just frankly don't agree with. So that's where I'm at right now. So it's not that I don't want to give them necessarily the documents that they're asking for, it's just that I don't have them. So if you were to say, Mr. Lopez, give them to me right now, I'm sorry, Your Honor, but I can't because I don't have them. I would need to get with my tax person to get those documents, like I explained to Mr. Gary. But other than that, that's frankly not that I don't want to produce them, Your Honor. I don't have them readily available to produce, because I was waiting for that link to see what I need and then upload everything. Because I did speak consultation with a lawyer, and I did ask her about that. She did say, hey, whatever they ask you for, you have to produce. So I was on board. I was just waiting for that email they said they were going to send to produce those.
Okay, Ms. Ortiz-Tang, do you have anything you'd like to contribute?
Not really, Your Honor. I'm not familiar with whatever link you might be addressing, but it is important that we get the information to be able to calculate.
Mr. Dehemesian, would you like to respond to that?
Yes, Your Honor. May I share my screen?
You may do so.
It's just a pleading, Your Honor. It's that we filed. So it clearly states on our pleading that these things should be produced to this address or this link right here, which is the email.
And Mr. Gary, when was that sent? Or was that post or pre?
This was served on
mediation.
These pleadings were served on you.
I think he showed up in court on the 24th. I don't know that he was served. Was he served? Oh, it looks like he was served. You were served on July 23rd, 2024 with the pleading, sir?
I'm not sure. I know there was a sheriff that came and served me for the mediation.
Yeah, that sheriff gave you documents. It's not a mediation. Okay, but he gave you documents. Did you read through what the sheriff gave you?
I have not, no.
Okay, if you read through what the sheriff gave you, it should be the original petition in suit affecting the parent-child relationship, and it contains what Mr. Dehemesian just showed you on the shared screen.
No, I understand that, Your Honor, and I should have
reading the pleadings and responding appropriately, sir. You can't just say, I didn't read them, I don't know, I'm going to bury my head in the sand. You're responsible for reading what is served on you.
Right.
Okay. So Mr. Dehemesian, I'm not sure what link he was talking about. I've never heard of the OAG using a link.
No, if anything, we were referring to the email, which is on the pleading.
Right, Your Honor, but like I said, in the past mediation with this last mediation that we had, I was told that they were
So
gonna
I'm
send
just
me.
going to object at this point to any further discussion of any settlement negotiations or conversations.
What was that?
I guess where I am right now is whatever happened last time happened. I want to make it clear that you're responsible for responding to the discovery that's in their pleading. And you have that pleading, you were served with it, sir. If you don't have it, you're responsible for getting it. You're choosing not to hire a lawyer, which is fine, but you have to take responsibility for this. So if you still have a copy of that pleading, great, you have it already in your possession. If you don't, you either need to go to the district clerk's office or contact the attorney general's office or whatever else you think you need to do. I'm not giving you legal advice. There's probably other options on how to get these pleadings as well. But you need to figure it out. You might have to Google it, how to get pleadings from Galveston County. It's your responsibility. It's not the AG's office. It's not my responsibility. And it's not Ms. Ortiz-Tang. It's their responsibility when they file something to get you the documents. And it sounds like the AG's office did based on the return of service I have for me. So that it's your responsibility to read and respond appropriately. What I'm concerned about right now is that last, whatever you want to call it, hearing, I want to call it, was in July. It's now October, and this child is still going without child support. Does anybody have any financial information where we can get something going?
I understand that I don't have anything written, Your Honor, and child support, but I am giving Julie $600 a month since last November. So I understand that that's not ordered and maybe legally it'd be considered a gift, but the child isn't in need or in want of anything. Whatever the child needs,
May I
I'm there for.
respond?
If I put him on my insurance for health, for dental, as soon as I was told to. So it's not like the child, I'm not giving them anything. I see him every Thursday. I have him every first, third, and fifth weekend. I take care of my son. I'm not leaving them out in the cold. You know, right now, like I said, and I have checks up for everything that I've given her throughout since she's given her everything, right? So like I said, Your Honor, I'm sorry. I understand that it's not a temporary order and it's not kept out and it's not by documentation or anything like that. I understand that, but I just don't want it to seem like I'm neglecting my son because that's not the case.
Ms. Ortiz-Tang, you wanted to respond?
I do. I want to respond that we acknowledge that he is sending $600 a month. We acknowledge that he has put the child on health insurance. Our issue is he's not visiting consistently on the first, third, and fifth, or every Thursday, as he stated. That's not a factual remark. My client, as far as statements and documents, Your Honor, we have bank deposits from up through November as to his income last year, but we want, corresponding information. They were in a joint account, and it's far below what his income is. It's far below.
The
And my
600?
600 is far below. Yes.
But that 600 was based on what we'd agreed on. It wasn't anything that was based on what we'd agreed on. One and two, I don't know how you're getting this fact that I'm not there every Thursday. I just sent her a text message today that I wouldn't be able to pick him up this Thursday, but if I could switch him for today, which I'm going to pick him up today after school. So that, I don't know where you're getting that information from, but I've been there every Thursday, every first, third, and fifth weekend. Even on the weekends that we had this temporary agreement between her and I, she's the one that didn't honor it. Because I'll tell you one thing, when I got married, my son was supposed to be with me that weekend and she didn't allow me to take him. Right? So it's not that I haven't been
Objection
there.
at this point to the narrative, Your Honor. and
But you're
objection
saying that I'm neglecting him.
Sir?
I'm not neglecting him. I'm
Sir,
sorry.
at this point, what I'm addressing today is discovery and possibly child support, because that's what's gaping. It's a gaping hole in your order where that's not being addressed. And okay, I did hear you say that you don't have the documents they're asking for, and you need to get with your CPA or your tax person.
Yes.
How long are you talking?
Your Honor, I'd have to go get with the CPA. I don't know. I just sent her an email. See when she responds. Like I said, it's not.
You didn't do this after the last hearing. Even if you were waiting on the link, you more or less knew what they were asking for. Surely you did. So I'm concerned about the lack of concern on your part to get this information. But has she responded yet with a time frame?
No, Your Honor. No. And I thought that they had that information. That's what they told me at the first mediation. They're like, well, we already have the information. But like I said, it's not a lack of concern, but I could see how you see it that way, and I do apologize for that. But no, I don't know.
Salary or are you a
Hourly.
W-2 employee?
Yes, I'm a contract worker.
So you're a contract worker. So
Yes.
Mr. Dehamajian, you don't have income information?
No, I have it, I just don't have it.
Mr. Dehamajian, you don't have income information, or do you?
No, Your Honor.
So
I know you're,
Ms. Ortiz saying, do you have enough information to prove up child support today for a temporary order until he gets better information to you?
What I have, yeah, I do, and it has us close to about $1,800 a month, Judge.
And he's seen these documents?
They're joint bank account deposits.
Okay. Why don't we proceed to set some temporary child support today, and that way we can give him some time, because it's probably going to take the CPA some time. Are the documents in existence already, or does your tax person first have to prepare documents?
no, I would assume that she has them filed somewhere.
Okay. Why don't we set some child support, and then we can reset the case to give you time to get better documents, which may affect the child support number. But this is kind of where we are at this point. Yes, Ms. Tang, if you want to call witnesses, we can proceed.
All right, Judge, thank you. I'm trying to open the documents on my computer.
Okay, take your time.
Let's see. Okay, so December 20. All right, I'm just going to call Mr. Lopez, Your Honor.
Okay.
Mr. Lopez, what is, sorry, please state your
Your
name
health
clearly for
insurance,
the
I'm assuming,
record.
will stay the same.
Yes,
Perfect.
please state your name clearly for the record, Mr. Lopez. And Mr. Lopez, what is your hourly rate at Blue Tide?
50 and out,
$50 per hour?
yes.
And do you work a minimum of 40 hours a week?
As of right now, it's minimal, yes.
Okay. And what is the most you've worked in 1 week for Blue Tide?
Most I work 72 hours that I had.
Okay. And with this job, do you get paid time and a half with your overtime? Yes or no?
Yes,
Okay. And so at times when you've worked that 72 hours a week, those extra 32 hours are paid at $75 per hour, correct?
yes.
And what job did you have prior to Blue Tide?
As a safety coordinator at Rev 1,
And with that job, what was your hourly rate?
no salary,
Okay. And what was your salary then?
135 a year.
And so at 135 a year,
But I only worked with them for about 3 months,
okay.
3-4 months.
And is it fair to say that you really don't want to pay child support in the amount of 20% of your net resources?
No,
And even though you get to keep 80%, you just don't want to do this 20%.
well, one, I don't think it's fair to say, or to be asked that I don't want to pay it. No, that's not the case. I'm not going to neglect my child, right? But I
Okay.
just, I just think it's unfair based on what she did, that I give her 20% of the salary when it's more than enough to sustain her at $600 a month, considering she has no bills.
Okay. And I'm going to object to non-responsive after. I'm not saying I don't want to pay what I'm supposed to pay, just, and then kind of ask the court to strike at that point. Let's see.
I'll sustain
So
that
with,
objection.
thank you, Judge. So you understand that at $50 an hour, and I'm doing the calculation now, Judge, so bear with
Thank you.
me.
Okay, take your time.
That gives you a gross of $2,000 per week, correct?
I don't have the calculations in front of me, but I was supposed so.
Okay. And without overtime, that would put child support at, and the health insurance was $387, is that correct, per month?
Something like that. I don't have the numbers in front of me.
And this is your only child, correct?
Yes,
And you understand that that would put child support at $1,268.60 per month?
That was
That's close.
1268.
Pardon?
1268 is what you said?
1,268.60.
Okay.
Yes, Your Honor. And you understand that that doesn't even account for your overtime at this point.
What was that?
That doesn't even include your overtime. You understand that, right?
It doesn't?
No, it doesn't.
No. Well, then, yeah, I guess if you're telling me that, you're the one getting the numbers test.
And so you're actually making more than $8,600 per month, aren't you? $50 an hour at times. So is it fair to say that, how often do you work overtime?
It's available.
Let me strike that. When was the last time you worked overtime?
When it's available last time,
Objection, non-responsive.
last week. I mean,
Sustained.
you're asking me questions that I can't give you a definite answer because overtime's not definite. If I can work it,
Okay.
if it's available, I can work it, but
When-
I said last
When
week,
was the last week? Okay.
last week,
And
correct.
how many hours of overtime did you work last week?
I don't know, I'd have to say maybe 30, 32, something like that. I don't know. I don't have my timesheet in front of me.
Okay.
Trying to,
And before last week, did you work overtime the week prior?
I believe so. The same amount of hours.
And how many hours was that again?
I'm gonna guesstimate right now 30, 32 hours. It's just normally if I can get overtime, it's either 60-hour week or 70-hour week or 68-hour week.
Okay. And so the $30 on top of, sorry, let me get my calculator out. So $30, 30 hours times 75 equals $22.50. So on top of the 2,000, you made an additional $22.50 last week, correct?
I would assume so.
Okay, so 75 times 30 is $22.50. So last week, your gross income was $4,250, correct?
I'd have to have the numbers in front of me to verify that, but if you say so.
That's a fair number. And then the week prior to that, which also had comparable amount of overtime per your testimony, you would also have had $42.50 just in that 2-week period alone, correct?
Okay,
So that's all right. So that almost has you in a 14-day period at $8,000, correct?
okay.
Okay. And so your gross income is probably well over the max of what's allowed in the state of Texas, correct?
That's what I've been told.
Okay. And so at the max, which is $12,184.66 for one child with child support at medical health insurance at $387, which I need to double check that number. That would make your child support amount $1,762.60 per month.
You put that
Okay.
at 1,700.
$62.60. Your Honor, may I share my screen?
Oh, you may do so. Yes. Thank you.
I'm
prior
actually
order just-
disabled.
Oh, if the host can give her permissions, please. Ms. Eschenberg, are you there?
Yes,
And Ms. Ortiz, the prior order did say his cost for insurance was $354.59.
Oh, thank you, Judge. 354.59. Can't see the correct screen. So, so 354.59. That puts child support at $1,769.08 per month for one child, health insurance, and the max.
Are you able to make that bigger by any chance?
Am I ever to what?
Make that a little larger?
Try good old-fashioned printing and see if that will.
Oh, yeah, that's much better. And
Your Honor, I would like to have this be my Exhibit Exhibit 1, and that would be Counter Petitioner's Exhibit 1. How do I?
if you email it to the Attorney General's office,
Okay,
they can get it to me. We can create a link. Does anyone have
Okay,
any
very good.
objection to me admitting this into evidence as CP Exhibit 1?
State has no objection.
And Mr. Lopez, I'm going to admit that
Okay.
into evidence.
all right. And then with that, Your Honor, I pass the witness.
Mr. De Jimenez, do you have any questions for Mr. Lopez?
No, Your Honor.
Okay. Do you have any other witnesses, Ms. Tang?
No, actually, Your Honor, I do not.
And Mr. De Jimenez, do you have any witnesses?
No, Your Honor.
And Mr. Lopez, the state does not represent you and you don't have an attorney, so I'm going to give you a chance if there's anything additional you'd like to say. And
But I
Mr.
just,
Tang, feel free to object if you believe a legal objection is warranted during his statement. It should be relevant to the issue at hand, sir.
I just want to know if this is gonna handle this paper with the temporary orders, because the child support, that's one thing, but like I said, I've talked to 3 lawyers previously, and I'm pretty much gonna be capped out in the state of Texas. That's fine. I'm not objecting on that at all. What I'm objecting is me paying her attorney fees, me giving up all my rights as a dad essentially to her, not being able to take my son out or make any type of mental health decisions for him, or just giving her everything where I'm susceptible to whatever she wants. That's what I don't want. So once I read this last night, there's a lot of things in here that I don't want to agree to, and I don't want to go forward. For example, me having to put a life policy on myself and have her be the beneficiary. Like
Let me
that's
just,
what-
stop you for a moment. Today, all I'm addressing is child support to get this temporary order moving in a bigger direction than it was before. At this point, I don't believe anyone's prepared to proceed on the full case today. True, yeah. So I'm going to reset the case for final trial. I'm not ruling on all those issues brought up. It sounds like they were pled for you to know them in that detail. Whatever the AG's office or whichever Ms. Ortiz-Tang pled for, those are issues that are before me. Just like I heard evidence today, I will listen to evidence. If anyone has witnesses, feel free to bring witnesses. If people have documents, definitely get them to the Attorney General's office through that email that Mr. Dehmesian showed earlier. And we'll handle all that at the next setting. You will be given a chance to talk to the Attorney General's office and Ms. Ortiz-Tang at the next setting, like you were today. If there's no agreements reached, you come out and you have a hearing before me. How am I going to rule? I could not tell you because I have not heard the evidence that you're all going to present.
Okay.
So it doesn't make that pleading go away, what just happened. It does get some child support officially started to Ms. Well, once I rule, it'll get some temporary child support to Ms. Henson, but all other issues that were pled for will stay out there. They're not addressed yet, and we'll just go from there. That's part of the litigation process. So is there anything else you'd like to say about the child support? Because that's really all I'm going to address today.
No.
Trying to make anyone proceed on something they're not ready to proceed on. And Star, it sounds like you've spoken to some lawyers. If you wish to hire a lawyer for this, feel free to do so. The state does not represent Ms. Henson or you, and the state rarely takes strong positions on visitation and custody and some of those issues you brought up. They're really here to address child support. So that applies to both you. You already have counsel, Ms. Henson. If you choose to get counsel, that's fine too, Mr. Lopez. It's completely
No,
up
I
to you.
will, definitely. Thank you.
So I am going to do additional temporary orders. You don't necessarily have to retype all the orders, Mr. Dehmesian, if you want to just do something called instead of like a supplemental temporary order or additional temporary order, and just
Yes,
write
Your
in
Honor.
there that the prior temporary order from July, signed by the court on July 26, 2024 remains in full force and effect. I'm going to set temporary child support at the max based on the testimony presented. So Mr. Lopez is ordered to pay Ms. Henson temporary child support of $1,769 each month, beginning November 1st of 2024 and monthly thereafter. Anything that was addressed in temporary orders can always be readdressed in final trial. And so everyone be prepared for that. Also, Mr. Lopez, please remember that I believe everybody still wants your financial information. Is that true, Ms. Ortiz-Tang and Mr. Dehmesian?
Yes.
Okay,
Yes.
so please remember you're still expected to respond to the discovery that was in the Attorney General's office's pleadings that you were served with. And if you need to get a
It's just
copy
I
of the
can't-
hire attorney, they'll certainly know how to get them. Otherwise, try to get yourself another copy so you see exactly what they asked of you. Mr. Dehmesian, when do you want to set trial for in this case?
How about January 22?
That is an in-person docket, but that's fine with me.
Your Honor, since it's an in-person, can we change it to January 27,
That's fine. Yeah, we can do January.
8:30?
We can do January 27th at 8:30. So January 27th, 2025 at 8:30 a.m. Okay, the state is going to draft this additional temporary order, which will be pretty brief, I think, to set the temporary child support, and it'll reset the case for that January 27th, 2025 at 8:30 a.m. date. The Zoom code will be the same, so it's the same way you got in today. And then they'll send it to you all through DocuSign so that you can review and sign off on this. And that is where we are. And so if you do hire a lawyer, you might want to do it sooner rather than later in case that lawyer wants to do any discovery. And we'll just go from there.
Okay.
Okay. And be sure to let them know what has happened so far. Give them copies of the pleadings and the orders and let them know that it is set right now for January 27th.
Okay.
And we're going to have you all go back to the breakout rooms while they draft that temporary order. But thank you all for coming in.
Thank you.
Thank you.
Do what you want, sir. You have the power.
Deny having received a copy of the complaint for custody?
Do what you want, sir. You got the power. I
I'm
done
just asking you, Mr. Westmoreland.
is do what you want. You got the power. If you want to give her sole custody,